We are going to bring in our panel to weigh in on this. We have two former prosecutors, David Bruno and Randolph Rice, to weigh in on this case. David, let me start with you. We've got a defense that says they are not really going to participate in this process. They told Richard Allen, you don't even need to submit an interview for the pre-sentencing investigation that typically comes before sentencing to help the court understand the details, because they felt that that's a state actor that they don't need to have their client subject himself to, and there's no value to it. Your thoughts on if that's the best option for Richard Allen's defense?
Yeah, they're going all in on the appeal. Richard Allen is continuing to assert his innocence per his attorneys. They're saying that in the memorandum as well. And really, there's nothing to be done here at the sentence either. I mean, because of Allen's age and the exposure that he has on these murder cases, it's essentially a life sentence no matter what. Even if the judge would go all the way to the bottom of the ranges, because of his age, he's in. So what they're doing is they're putting all eyes on the appeal. They firmly believe that they were curtailed in their presentation of the evidence. They wanted to present this odinism defense and third-party liability, which they were precluded from. That will be point one on the appeal, but let's just see what the appellate court thinks and whether or not that made a difference or not.
Yeah, he's 52 years old now, and his team thinks that even with the best good behavior and time credit, he would still serve about 33 3/4 years. So he would be 85, as you mentioned, before he would get out, even if the judge goes as low as possible. But Randolph Rice, to not have his family there, to not have him to speak at all inside of this courtroom, to not even put on any evidence, does seem like a bold move, if nothing else, in the court of public opinion.
Yeah, I mean, I think David makes a good point, is that he just sort of said, this doesn't matter today. Whatever I say, whatever my lawyers say today really has no bearing on what's going to happen to my future. And he's looking toward the appellate process. I am very interested, though, to hear from the family of the two girls, because I think today is a very important day in the process of healing. Representing families in the past, I've seen how the day that they get to go to court and say something out loud, maybe directed towards Mr. Allen, that's a healing day for the family. So I'm very, very hopeful that that helps them in this process of healing.
Yeah, and it has to have been very hard for them to comply with what the court has imposed, not be able to speak about these two precious lives that were lost, but that may be changing today. We may hear a lot more. We know we're going to hear from at least those who were involved in the task force, according to what Barbara McDonald just said. David, the mitigators that the defense did put in their sentencing memo could still sway the judge. Even though the judge isn't going to hear any evidence from the defense, they mentioned that he was in the National Guard. He had a 10-year service there. He suffers from mental illness. He is the breadwinner in his family, and he doesn't have any criminal history. Do you think without anything more in terms of arguments that the judge still may go on a lighter end, or is this something where 130 years, the max, may be what we see coming down?
Yeah, when we talk about these sentencing proceedings, the judge has a job to do. They have to balance the aggravating factors with those mitigating factors. And those aggravating factors are egregious. I mean, the nature of the death, there's two juveniles that were murdered, the way that they were murdered and positioned in the crime scene, I think are going to clearly outweigh all of those mitigating factors that were presented by the defense. And while those are good mitigating factors to bring forth by the defense, the aggravating factors are clearly outweighing this case.
Absolutely, and those victim impact statements will no doubt be heartbreaking and difficult for everyone inside of that courtroom to hear. We are looking ahead, just because the defense has put the spotlight on it as well, Randolph, to this appeals process. What do you think the success is going to be there, if any at all, and what do you think they will focus on in that appeal?
Well, yeah, that's the $1 million question, right? Is what the appellate court is going to find. Do they have enough grounds to actually make a difference or sway that court? Because they're going to be arguing about bad actors, state actors, that he didn't have a fair trial, that there was information that was released. So the court's going to have to look at, obviously, precedent and say, does this affect the fairness of this trial? Does this justify us giving him another trial? Remember, it's not an appeal to get off. This is an appeal where he's saying, hey, look, I didn't get a fair trial. I wasn't treated properly. This evidence shouldn't have come in. I need to have another trial. So, you know, I'd love to have a crystal ball and be able to tell you what's going to happen. It's just hard to tell in these appeal processes nowadays.
And that's what the defense is banking on. Randolph and David, thank you for weighing in on this case. We have more cases to get to. Coming